All right, let's jump right into it. If you're looking to really master the complexities of Admiralty law, you're in exactly the right place. Today, we're basically skipping the massive law school tuition and replacing a traditional, lengthy lecture with this complete, self-contained explainer. We're going to break down one of the oldest and honestly most fascinating surviving doctrines in maritime law, general average. I'm going to walk you through this step by step, from the ground up, to make sure every single legal concept clicks for you. Here is our game plan for mastering this today. We're going to start with the doctrine and its elements. Then we'll hit the foundational law. Next up, the actual mechanics and adjustment, followed by a huge modern case study you'll definitely recognize, the Ever Given. Finally, we'll wrap up with a concept recap to lock it all in. Section 1, Doctrine and Elements, the framework of sacrifice. So what exactly is this topic, and why should we even care? Well, here is the entire concept boiled down into a single sentence. When property is sacrificed to save a maritime venture, everyone saved must proportionally share the cost. That is the strict thesis of general average. And it matters because in a life or death maritime emergency, the master of a ship literally shouldn't have to hesitate or negotiate over whose property gets destroyed to save the crew. By legally guaranteeing that everyone who survives the peril shares the financial pain, the law actively encourages swift, life-saving decisions. Now, the plain language idea for this actually traces way back to ancient times, specifically to the Lex Rhodia, or the Rhodian Sea Law. But since we're in the modern world, we need a precise legal definition for your notes. The absolute classic definition today comes from the York-Antwerp Rules, specifically Rule A. It states that a general average act occurs when an extraordinary sacrifice or expenditure is intentionally and reasonably made for the common safety to preserve property involved in a common maritime adventure from peril. So the crucial takeaway here is that for this ancient doctrine to apply today, 6 essential elements must be present cumulatively. Listen, if even one of these is missing, it's a no-go. It's not general average. First, you need a common peril, a real, immediate danger, threatening the ship, the cargo, and the freight altogether. Second, the act has to be voluntary and intentional, not just an accident. Third, it's got to be extraordinary, so way beyond normal voyage costs. Fourth, it must be a reasonable response. Fifth, it has to be for the common safety of the whole adventure. And finally, some actual benefit must result. I mean, if the ship sinks anyway and everything is lost, there's nothing left to contribute toward, right? Let's ground this with a concrete analogy. Picture a ship caught in an absolutely terrifying storm. The vessel is taking on water, it's dangerously heavy, and it's going down. The master makes a deliberate, calculated choice. They take the heaviest cargo, which happens to belong to one specific merchant, and they throw it straight into the churning sea just to lighten the ship and keep it afloat. And that intense scenario perfectly illustrates our very first legal term, jettison. Jettison is the act of throwing cargo overboard to lighten a distressed ship. It is literally the original textbook example of general average straight out of the Lex Rhodia. Think about it. We have an intentional, extraordinary sacrifice made for the common safety. The rule dictates that the poor merchant whose cargo was jettisoned doesn't just eat that massive loss alone. Nope. Every other cargo owner whose goods actually make it to port safely has to chip in and compensate them. Okay, now check out this critical comparison, because this is exactly where the strict legal definition matters in the real world. Imagine a fire breaks out in the cargo hold. The damage caused by the fire itself, that's totally accidental. And because it's accidental, fire damage is not general average. But what about the water damage caused by the crew intentionally flooding that hold to put out the fire? That water damage is a voluntary response to a peril. So that voluntary firefighting water damage absolutely is general average. You see the distinction there? Only the intentional, voluntary response counts. Beyond jettison and firefighting, there are a few other classic scenarios that check all our strict boxes. First is voluntary stranding, which is when a master deliberately runs the ship aground to avoid something much worse, like sinking in the deep ocean. Another one is cutting away damaged masts or rigging to stop the vessel from capsizing. And finally, we have port of refuge expenses. This covers the massive costs of diverting a ship to a safe port, which includes unloading and storing cargo while they make the necessary repairs to safely finish the voyage. Every single one of these is a voluntary, extraordinary sacrifice.
Section 2, Foundational Law, Berkeley v. Presgrave.
Now that we've got the framework down, let's dive into our first mandatory case brief to see exactly where the common law cemented all this. We're looking at Berkeley v. Presgrave, decided way back in 1801. The facts and the core legal issue here centered around an early English dispute over property that was voluntarily sacrificed to save a maritime venture. The court had to figure out what exactly constituted a valid claim where one party could legally force everyone else to pay up for a sacrifice made at sea. The exact wording of the court's holding is absolutely crucial here. The court ruled, and I quote, "A general average loss must come from voluntarily and intentionally sacrificing one party's property to save the whole adventure from perishing." Notice how flawlessly that maps onto the 6 elements we just talked about? So you might be wondering, why do we care about an English case from 1801? Because this specific ruling gave us the foundational common law articulation of general average. Even though it's over 2 centuries old, this exact reasoning is still the bedrock for how maritime disputes are resolved in common law jurisdictions today. It's a hugely important piece of historical precedent. Section 3, Mechanics and Adjustment, Applying the Rules. All right, we know what the law is, but how is this ancient idea actually governed and applied in today's highly complex commercial world? Well, let's see how this builds out. There's a vital distinction to make here. Unlike a lot of maritime laws, general average is not governed by some overarching international treaty or convention. National laws are just way too all over the place for that. Instead, the shipping industry standardized it themselves by private contract through the York-Antwerp rules. Drafted by the Comité Maritime International, we're currently on the 2016 version, by the way, these rules are explicitly copied and pasted into shipping contracts like bills of lading. So it's private contract law, not a global treaty, that makes this entire system function across international borders. Let's patiently walk through the actual mechanics. Here are the 4 sequential steps of how adjustment functions when disaster strikes. First, right after the event, the master formally declares general average. Second, an independent specialist called an average adjuster is brought in. They calculate the total value of the sacrifice made, as well as the contributory value of the ship, the cargo, and the freight at the exact moment the voyage ends. Third, every single party has to pay a proportional contribution based on their cargo's value. And fourth, and this is a big one, because this math takes months, sometimes years, carriers absolutely will not release the cargo right away. Cargo owners are forced to post a general average bond and a general average guarantee just to get their goods off the dock. Now, hearing that, you're probably thinking, wow, that sounds insanely expensive and risky for the cargo owners. And honestly, it absolutely is. But this is where we find a natural bridge to marine insurance. General average contributions are actually standard insurable losses. Both hull and cargo insurance policies typically cover an insured's general average contribution as a matter of course. This financial safety net is literally the only thing keeping global shipping from totally grinding to a halt every single time a sacrifice is made at sea. Section 4. The Ever Given, a Modern Case Study. To really hammer home just how relevant this ancient doctrine still is today, let's look at a massive modern case study. I guarantee you remember this one. We're talking about the Ever Given in March 2021. This absolute behemoth of a container vessel grounded sideways in the Suez Canal, completely blocking one of the busiest shipping lanes on Earth for 6 agonizing days. The entire global economy basically held its breath while salvage crews worked around the clock to refloat her. Now, because the monumental expense of the tugboats, the dredging, and the salvage operations benefited the entire adventure, meaning the ship and all its cargo, the ship owner took the severe legal action of declaring general average. This meant they literally required every single cargo owner who had a container sitting on that ship to post security before their goods would ever be released at their destination. Now, what's truly wild about this, and why it's such a critical part of our legal study, is the sheer scale of the fallout. It forced owners of completely undamaged cargo, stuff that was sitting perfectly safe inside its containers, to pay vast sums of money just to get their own property back. It triggered a massive, multi-layered legal and financial controversy across the whole shipping industry. Overnight, the Ever Given became the standard contemporary reference point for just how powerful and how disruptive general average can be in the modern world. Section 5. Concept Recap, Reviewing the Masterclass.
Okay, we have covered a tremendous amount of ground today, and we're going to firmly lock all this knowledge into place right now. Let's do a quick structured review of everything you need to know in the exact order we covered it. We started way back with the ancient origins in the Lex Rhodia. We learned the precise modern definition found in Rule A of the York-Antwerp Rules. We examined the foundational common law holding from 1801 in Berkeley v. Presgrave. We discovered that today, this whole system is applied via private contract through those York-Antwerp Rules. And finally, we saw it literally paralyze modern supply chains with the Ever Given.
I want to leave you with one final provocative thought. You've seen the law. You've learned the strict rules of sacrifice. But think about this. If your perfectly undamaged cargo is legally held hostage to pay for a ship's rescue, is the ancient doctrine of general average actually still fair in the modern world? It's a really tough question, and it's one the maritime industry wrestles with every single day. Thank you so much for joining this explainer, and definitely keep that question in mind as you continue your journey into maritime law.